Okay, welcome everybody. Thanks for coming to our Law After Lunch lecture today, which is given by Professor Fikremarkos, Merso, Birhanu. Most of you maybe know him already. He is a regular guest of our institute. Fikremarkos, as I said, we know each other for 15 or more years. He has been visiting the AD professor for one semester here some time ago at our faculty. He is a constant and regular visitor, teaching more or less every summer a course. This semester, a course on access to pharmaceuticals, to medicine, and intellectual property rights. But today, we're doing something similar, but with a different focus. It's on the new WIPO treaty on intellectual property and genetic resources and traditional knowledge, which is the interesting aspect in this regard. How to protect traditional knowledge, Fikremarkos probably will say more on that, is not old, but an issue that is discussed for 20, 25 years, something like that. I already talked with Fikremarkos. I had a PhD student, one of my first PhD students actually, since I'm a professor, more than 15 years ago, has written on traditional knowledge, culture, and IP protection. So it's an old topic, but negotiations on that in order to have new treaties take time, and there are a lot of competing interests in this regard. We will hear about that. Fikremarkos has worked with the Secretariat of the African Continental Free Trade Area for the last 2 years and is now on his way to the US, where he will teach at Case Western a course next semester and then hopefully come back to us again. But anyway, you have the floor.
Okay, thank you very much, Christian. And, really happy to see faces that I already know over the years. I have been visiting Halle, he said, for long now, like for 15 years or more. So I know most of you at least by face. Only few people that I don't really know, and I'm happy to be here, back to Halle this summer. So when I was asked about a possible topic for discussion, law after lunch, which I normally do when I can, I say it's maybe a good idea to say a few things about a very recent development, so to speak. Just last month, the WIPO diplomatic conference adopted this treaty. The treaty in relation to intellectual property, genetic resources, and associated traditional knowledge. So as Christian said, this is not really a new issue. Most of you probably know about it. What's new is that we have a treaty or kind of treaty. I think that's the only thing that makes it new. After debates for long decades, now we have at least some kind of treaty that will settle the debate. Is another question that we're going to see, whether this treaty will bring an end to the debate we have on genetic resources, intellectual property, or genetic resources and traditional knowledge is a different question, but we have at least some level of international agreement on this subject, which has been very difficult to agree on, and this is what makes it new. So I will just give you a general introduction and background, and then look into the key obligations under the WIPO Treaty. What are the key obligations? What's new in this treaty? And I think this is a very short treaty. If you go through it, it's 22 articles, and the most important articles are like 3 articles. The rest is like cooperation, decision making, entry into force, amendment, interpretation, and so on. Substantive provisions are really foreign to me in this protocol. And then finally, I will just give you my own reflections and open the floor for discussions, of course. As I said, disputes on the so-called misappropriation of genetic resources. That's at the heart of the dispute, not only genetic resources, but also traditional knowledge belonging to indigenous communities, local communities. And there has been a debate, and that debate has been going on for long now. The idea is that, yes, the genetic resources have been preserved by local communities, traditional people, indigenous people, but they are not getting their fair share of whatever revenue is generated from the use of the genetic resources or the traditional knowledge. They are marginalized, although they have been preserving these resources and making them available for commercial exploitation. They have been left out from the system for long, and therefore this should not continue. That was basically the debate. And then there are clear cases where community resources were taken without the consent of the communities and without any beneficiary arrangement being made and protected by intellectual property rights. The problem with intellectual property, I mean, if someone takes this from a certain community and protects them by a patent, for example, it is completely a monopoly. Patent is a monopoly. So even the local communities should get permission to use these resources. So there was a lot of controversy. These are some of the examples. By the way, some of the patents have already expired. Patents expire after 20 years. But just to show you that it is not, we're not talking about just ideas, but it's really practically, there are so many instances where patents were given with questionable inventiveness or novelty. These are clear requirements of patentability, but already the knowledge is known to the communities. The communities have been using them for generations, and they have been taken away and protected by patents. So that debate continued and continued, and then we have the Convention on Biological Diversity that tried to articulate the issues more precisely. Before that, the debate was there, but they were not really well articulated in a treaty form. And I think the Convention on Biological Diversity is the first maybe comprehensive treaty that tried to articulate the issues properly in a treaty. We know that Convention on Biological Diversity is concerned mainly on conservation of biodiversity, but in doing so, it also provided some guidelines, rules on how to use genetic resources and the idea of fair and equitable sharing of benefits coming from the utilization of the genetic resources or the traditional knowledge, as the case may be. And of course, that became what we now call the disclosure requirement. First of all, when a traditional knowledge or a genetic resource is taken from somewhere and used as part of the invention, then the country that supplied the resources should be disclosed, and there should be arrangement for mutually agreed terms based on prior informed consent for the sharing of benefits. So it means access to genetic resources or traditional knowledge will be based on the prior informed consent and benefit sharing of, well, ideally should have been communities, but still the state here, because the state is party to this convention. The because CBD did not go to the extent of asking the consent of communities, but the state should give its consent. Now, so this is the beginning of really a clear, articulated disclosure requirement in order to make sure that this is the objective, in order to make sure that there is a continuous, flow of genetic resources and traditional knowledge. The people who are preserving them, who are keeping them, should be incentivized, and they should get their share of benefits so that they will continue to preserve the genetic resources and traditional knowledge, provide them, for free. Basically, they were providing it for free. And by the way, local communities do not normally ask for resources, but when someone comes and tries to exploit it commercially, of course, it's natural that they should be compensated in that regard. And then the issue found its way in the WTO. So WTO here, in the TRIPS Council, there were proposals from so many countries, mostly developing countries, but to some extent some European countries, for inclusion of this disclosure requirements into the TRIPS agreement. So according to that proposal, which has not yet been settled, the TRIPS agreement could be amended to require disclosure of genetic resources, provide proof of prior informed consent, and benefit sharing. So before a patent applicant makes that application, these obligations become now part of the patent application process. There should be a disclosure of the place, the country where the resources come from, and then there should be a proof of prior informed consent and benefit sharing. So it's it's supposed to be a mandatory requirement, although there is no yet consensus at the WTO. It continues to be part of the agenda. It found its way also in the Doha Development Agenda, which has not yet been concluded, unfortunately. So in the Doha Declaration, the TRIPS Council was specifically instructed to examine the relationship between the Convention on Biological Diversity and the TRIPS Agreement. And it's already in the outstanding issues, paragraph 12 of the Doha Declaration talks about this. There is a clear mandate for reviewing the Convention on Biological Diversity and the TRIPS Agreement. But as I said, there is no any consensus yet. But there are some countries that refused even to consider this in the TRIPS Council. They say that the TRIPS is not the appropriate place to discuss these issues. Countries can do it at their own national level. They can prescribe these conditions in a different law. For example, the patent law is not the right tool to handle this issue. Patent is simply a certificate of invention. We cannot, overburden the patent system with additional difficult to prove conditions. For example, if we ask a patent applicant to prove benefit sharing, it means additional bureaucracy, additional conditions to be complied with, and there is incentive maybe missing for patent applicants to make their application. So that division continues. More developing countries wish to have this included in the TRIPS agreement. Others, they are not ready to include it in the TRIPS agreement. That debate continues at the TRIPS Council. And then the same debate continued in WIPO, World Intellectual Property Organization. And finally, after decades of negotiation, we have this WIPO treaty just last month. This is basically where it started and where we are now. So now let's see a few things about this WIPO treaty, whether the WIPO treaty really addresses the core issue that I described before or not. I think we can look at, first of all, I think it's important also to look at the objectives of this treaty. As you can see, the objective is obviously very narrowly defined. So it is about bringing about transparency, quality of the patent system with regard to genetic resources and traditional knowledge and associated genetic resources. Prevent patents from being granted erroneously for inventions that use genetic resources or traditional knowledge associated with genetic resources. So you see, it is a very narrow objective clearly. Already from here, you can see the ambition of this treaty is quite limited. So it's only within the patent system, and it's only to make it more efficient and transparent and so on and so forth, and to avoid as much as possible the granting of erroneous patents on this genetic resources or traditional knowledge. Now, the most important obligation for us, and in fact, the most important obligation, the most important article in this treaty is Article 3. It talks about the disclosure requirement that I have talked about. Now, the way the disclosure requirement is articulated in Article 3 is interesting in a way. First of all, with regard to a patent application based on genetic resources, the applicant should disclose the country of origin of the genetic resources. So when somebody's invention is based on genetic resources, I will come to that point, what it means based on genetic resources. So the applicant is required to disclose the origin of genetic resources. Of course, the question is clear. So the origin, where is the origin of this particular genetic resources? It could be very difficult, obviously, because genetic resources have been moving from place to place, centuries of movement of genetic resources. It may be difficult to trace exactly the origin of resources. That's understandable. In which case, when it is unknown, it is the source of the genetic resource should be disclosed. So, in principle, the origin, if the origin is difficult to know or it's unknown, the source means the immediate source from where the genetic resource has been taken. Similarly, when the application is based on traditional knowledge, the same obligation applies. So the applicant should disclose the origin of the traditional knowledge. So what is the origin of the traditional knowledge could be, again, very controversial. In that case, again, the applicant can provide the source. So I think it's understandable. I mean, in some instances, yes, it could be difficult to really know the origin of a genetic resource or the origin of a particular traditional knowledge associated with genetic resources, in which case I think it's fair to require the source. The source is obviously known, but if the origin is unknown, it's better to allow the patent applicant just to show, to indicate the source. So another important provision. So what's the failure? What's the consequence of failure to disclose? I think this is maybe at the heart of all the discussions we have. So yes, disclosure of origin or source, but what is the consequence for non-disclosure? And I think that's Article 5. Now, probably below our expectation, this Article 5 just leave it to national governments, national consequences. In fact, it is up to the contracting state parties to put in place appropriate legal remedies, measures addressing the failure to provide that information. So you see, the treaty is shying away basically from the core of the issue here. So there is no any prescription. So you declare what if you fail to disclose it? Well, it's going back to national level. I mean, we know that many countries have already put in place laws already, but we are talking about an international treaty. And then it's taking it back to the national level. We understand the reasons, but that's how it's agreed here in Article 5. In fact, a very controversial prescription of this article is that no contracting party shall revoke, invalidate, or render unenforceable the conferred patent rights. So this means, yes, national laws can take measure, but they cannot revoke, invalidate, or render unenforceable a conferred patent right. So it means even though the obligation has not been made, no disclosure has been made, the consequences are really very lenient, as you can see. The patent cannot be revoked, shall not be revoked, cannot be invalidated. Rather, what this Article 5 is saying that you have to find at the national law other, like for example, penalties. So you can penalize the patent owner, $500,000, whatever. There could be other administrative like penalties, but the patent should continue. So the patent cannot be revoked. In other words, the patent will be valid means we know that this genetic resource comes from a certain traditional community. So they will continue to suffer for 20 years. There is no beneficiary, there is nothing. It means the patent will be valid. It is a monopoly, we know it. It will be a monopoly for 20 years. So communities will not have any resource at all, because the patent continues to be valid. And patent is like exclusive. It's exclusive. Nobody can use the patented invention without the permission of the patent owner. I think that's where we have really a significant controversy here. If you put in place an obligation, and then the consequence of that, and take into account also several considerations. If the patent is going to be valid, what does it mean? So it means the monopoly will continue, including communities cannot have access to that, protected innovation. In fact, post-grant sanctions under national law can only be prescribed when there is fraudulent intent on the part of the applicant. Even more interesting. So even to take a post-grant measure, there should be a fraudulent intent on the part of the applicant, which is obviously controversial. Now, just some reflections. So those are the core, by the way. If you go through this treaty, the rest is like more of administrative and other provisions. I think for me those are the three provisions, the core provisions of the treaty. It's a very short treaty, as you can see. Yes, of course, the disclosure requirements. Yes, it could be very attractive in theory, but it's remained imprecise. I mean, it is fraught with difficulties. For example, the first issue is like what to disclose. What to disclose, the source or the origin. I think the WTO treaty, as I said earlier, talks about origin, but if unknown to the applicant, the source can also be disclosed. That's what we said Now the question is, should we leave it that level? So it means it's simple. It's just the applicant will say, okay, the source was this country. Or the applicant could simply say, oh, I don't know the source. I don't even know the origin, both. There is no additional requirement, unlike, for example, other national laws, for example, provide additional obligation on the part of the applicant, that is to make a reasonable inquiry. It's like, it doesn't seem to be taken seriously. The patent applicant is going to say, oh, I don't know. Okay, here is your patent. Something like that. I mean, at least there should be evidence that the applicant has tried reasonable inquiry to establish. Otherwise, it's like, whatever the applicant is saying will be accepted, and then it doesn't solve the problem, really. And there is no additional requirement in this regard. Now, do we need also a proof, or just whatever the applicant says will be sufficient? Some other laws, again, proof is required for that. Well, you can imagine the pros and cons of requiring proof in this case. It could be a little, overburden, maybe to prove how can the applicant prove, the source or origin of genetic resources. Could be a little hard, although some national laws include that clearly. There should be a proof. So, but I think we have to also be very careful not to go too far, and complicate the patent system anyway. It's arguable, but it doesn't require any. There is no any additional requirement here in the WIPO treaty. And now, another issue is, how about the office that receives the application? Is there any obligation on the part of the officers? Okay, so I am a patent applicant. I just say, okay, I don't know about this source or whatever. Are they going to accept it, or are they going to do some preliminary, at least preliminary search to accept or not? I think normally we expect that as a patent office, as part of their search, they should do some preliminary examination to have a reasonable, understanding of what has been stated. But the treaty clearly says that contracting states cannot impose obligation on offices to verify the authenticity of the disclosure. So it means the IP offices that receive this application, they cannot be asked to verify whether that's true or not. Whether that's true or not. Again, that's really another, another limitation. We know that in some cases there are databases for traditional knowledge, for example. There are databases. They can easily search and look whether what the applicant says is true or not. And there are databases available freely. But there is no any requirement. It means it's just the applicant will be submitted, the applicant will say, I don't know the place, whatever, and then it will be processed. There is no any clear obligation here on the part of the officer. That's another problem here in this treaty. So the second issue is what kind of use of the genetic resource or traditional knowledge will trigger disclosure obligation. In other words, what kind of relationship should exist between the invention and the genetic resource, traditional knowledge, for the disclosure requirement to apply? Well, as I said earlier, the WIPO Treaty used the term based on genetic resources or based on traditional knowledge associated with genetic resources. So what's the implication of this? So when exactly is disclosure required? The way the treaty put it is based on, which is a very huge threshold, obviously. In other words, even though some traditional knowledge, genetic resources is used in the invention, as long as that invention is not based on the genetic resources, then there is no disclosure requirement. In other words, not every use of genetic resources, traditional knowledge, will trigger the disclosure requirement. The disclosure requirement, it is entirely based on. It is entirely based on, it's not part of. The terminology used is really heavy. And it was a deliberate use in this regard. So based on means, basically the entire invention should be like a traditional knowledge related or genetic resources related. How about other uses of genetic resources? Like in any invention, there may be a part of the invention that makes use of a certain genetic resource or traditional knowledge. We cannot call it, this is an invention based on genetic resources. Other terminologies, alternative from other national laws. For example, when genetic resources or traditional knowledge utilized in the development of the claimed invention. So if you compare this with based on, I think there is a huge difference. A huge difference because in this language, whenever a genetic resource or traditional knowledge is used, it's not based on, whenever it is used, it should be disclosed. It's a very broad obligation. But the WIPO Treaty deliberately made it based on, which means the invention should be entirely traditional knowledge or genetic resources related. Again, in all other cases, the disclosure requirement will not be applicable. I think that's also another really concern. The most important concern, I told you earlier, is the consequences of failure to disclose. So it means now this treaty is leaving everything with some guidance to national laws. National laws can prescribe administrative rules, sanctions for failure to disclose. But that administrative rule cannot include the revocation, invalidation, or rendering enforceable the already granted patent rights. Well, I don't know if this really adds anything. That's really the question now. I mean, countries are doing this. So it means everybody should go to the concerned patent office and challenge the patent office. That already we have it. Already we have it. Look at the examples. We have so many cases where patents on genetic resources were successfully challenged. It's already national mechanisms. We are here, I mean, the treaty where it was supposed to have like an international perspective, not a national perspective. And this is where the international treaties are needed. But it leaves everything to the national law. Well, in the US, successfully, patents on the basmati rice challenged by the Indian government successfully, and European Patent Office also, the name tree, they successfully challenged it. I mean, it's possible. It's possible. The problem is that's why we need international system. The problem is, first of all, it's very, very expensive. You see, for example, traditional communities cannot do this. They don't have the resources, even the technical capacity. Only few, and then these are sponsored by governments. It is possible to challenge at the national level, but it is really complex, and very few cases, and very expensive. And that's the purpose why we were looking for international treaty, but the way we see it, the consequence of failure to disclose is completely unaddressed here, and it's left again back to even a dangerous prescription saying that the patent cannot be revoked, invalidated. But I know many laws, national laws, say that it should be invalidated. If the requirement is not complied with, it will be revoked. If the patent is given, it will be revoked in many laws because it doesn't fulfill the requirements of that clear mandatory requirement. But here, we don't have it. That's another difficulty. In addition to that, the scope of the obligation. It is only the declaration of origin or source, but the other issues are not obviously included. And it's really about the prior informed consent and benefit sharing arrangements. They are not included. It means the whole objective. I mean, if you say that the disclosure requirement is good for the integrity and the transparency of the patent system, legitimacy of the patent system, I don't see any logic why a treaty stops somewhere and say that only disclosure of origin, we don't have to talk about prior informed consent of the communities that provide the genetic resources or the traditional knowledge, as the case may be, if they are not part of it, or at least their informed consent is at least secured, then the whole purpose, the whole issue becomes again questionable. And again, another limitation in my view of this treaty is it applies only to patents applications. But there are also instances where this problem happens in other copyright areas. For example, we know that copyright is also an area where we have a problem. And it's not clear why. Of course, the treaty says that in the future, other intellectual property rights could be covered. But for now, at least, it is like only patents, not copyright or any other intellectual property, again, which is a limit for me. And then, talking about traditional knowledge, I think it's only a narrow component of traditional knowledge that has been covered. A traditional knowledge associated with genetic resources. The rest, I mean, so it means we're not talking about traditional knowledge in its own right. It's not. It is only that part of traditional knowledge associated with the genetic resources that we are talking about. So it means there is still a huge gap at the international level with regard to traditional knowledge in general. I know that there were discussions in the WIPO to have like some regulations on traditional knowledge per se, traditional knowledge per se. This one, very narrow component of traditional knowledge being addressed here. So it doesn't address all issues. Just for comparison, this is where I was working at the FCFTA. And the FCFTA has an IPR protocol, intellectual property protocol. And, that's how the issue of genetic resources is addressed in that protocol, which is already adopted. So I think the terminology could be questionable, but sub 2, paragraph 2 of Article 20 of that protocol, just for comparison to you, says state parties shall require that an applicant for any category of intellectual property. Obviously, it doesn't make a distinction between copyright and patent and so on, any category of intellectual property, drawn from or developed using genetic resources, should provide the following information. So the source of the genetic resource utilized in the invention or creation, proof of prior informed consent from the competent authorities under the relevant national legislation, proof of fair and equitable benefit sharing. I think that is a complete set of the disclosure requirement. So So you see, other initiatives, the Andean community have already incorporated this. So regional initiatives have already been taken over. The WIPO Treaty, I don't think the WIPO Treaty is really leading now. It has been overtaken by other regional treaties. So this protocol has been adopted by 55 African countries already. So it's already more comprehensive in its approach. It covers all intellectual property rights, and it requires all the disclosure requirements, not just disclosing the source or whatever, but also proof of prior informed consent. So it means the patent applicant should enter into a contract with the relevant state or communities and then bring the proofs. We have agreed to share this benefit, this amount of benefit for the communities, and this is part of my application. So that is just for comparison. So in conclusion, so what is the value addition of this treaty? I have been grappling with this question. I know I am running out of time. Am I okay? Okay. Well, I mean, on a positive note, it is the first international initiative to deal with whatever disclosure in a narrow context at least. It is something, it's just the beginning, maybe. It's just the first initiative where we have some international regulation of this issue. To that level, you know, it's okay. I mean, it's a treaty. But as I said earlier, many countries have already put in place their own national laws, and with more stringent requirements. So I don't know if this treaty will take them back, or will countries be interested in this very weak and minimalist treaty? That is really questionable now. Disclosure requirement is very narrowly defined, and it's also weak. As we saw, it's not only narrow, but the way it's stated weak. You just declare it, and then if you don't know it, you just take your patent. That's like that. So that's very weak. To me, it's not even clear if there is a mandatory and binding disclosure obligation. One may argue that there is no. Of course, you can say, I mean, there is a provision talking about disclosure, but in reality, for me, there is no disclosure. I could be challenging, but I think that's how I read it. I think there is no disclosure in this treaty. Now, it's very weak from the perspective of indigenous people, local communities. Their consent is not required. Benefit sharing is not guaranteed here. So they are not part of the equation here. They are not part of the system. And by the way, one important contribution of this treaty would have been what they call the information system on genetic resources and traditional knowledge. This is like a database, an international database registering whatever traditional knowledge we have in every country, traditional knowledge, traditional cultural expression, and genetic resources. This is very, very important because normally what the problem is that many of the traditional knowledge by communities are not registered. So we don't really know. So a database of this is very, very critical, even for the protection of local communities, indigenous people. Many countries, like India, try to have a national database for especially traditional knowledge, so that you can easily check whether that traditional knowledge is existing in this part of the country, in that part of the country, in this community. It would be easier. And there was an attempt here to establish that kind of system, information system on genetic resources, but it's not mandatory. It's not mandatory. It says may. Contracting states may. It doesn't exist for me in that case. In an international treaty, if you say may, obviously it doesn't exist in this case. So I know it is may because there was no consensus. And if it's may and there is no consensus, I mean, it doesn't work in that case. So this would have been a very important contribution of this treaty if it was like mandatory. If there is a mandatory international information system on genetic resources and traditional knowledge, I think it would have been a very important addition to me, but the way it's stated is not mandatory. Will it prevent the grant of erroneous patents? I very much doubt it, from what I said earlier. I think for me, this treaty, the impact of this treaty on existing problem is really quite limited, if any. I know some of you may have a different perspective, but from what I see here and from what I know from in this area, I think the contribution is quite questionable. I don't think this will prevent erroneous patents being given. And I don't think this will bring fundamental change in the existing genetic resource and IP governance, traditional knowledge, IP governance. I think the debates, the broader policy debates of access and benefit sharing of the benefits from the exploitation of genetic resources and so on, that will continue. I don't think this will stop here with this treaty. This treaty is really, its contribution to me is a little controversial and limited. So let me stop here and see if there are any questions. That's what I think about it, but I would be happy to hear from you. If you have a different view, you can also have a different view, of course. And for your attention.
Floor's open. Fikremarkos.
Okay, so what did WIPO intend, how do they envision a disclosure being useful of any sort? Is it just based on transparency, or is it the idea that then when these national databases have clearly searchable ways to identify where traditional knowledge exists, that it then gives them the opportunity to challenge an erroneously granted patent? Or, I mean, you presented very well that it doesn't seem to work at all. So my question is, how did they think it was going to work?
Yes, that's my question actually. Yes, that's also my question. That's what I said earlier. Well, I think this is a very controversial treaty. I'm sure it will continue to be controversial. I mean, it's supposed to address a key problem in the patent system. It's a lack of disclosure, granting of erroneous patents, and so on. And it's ended up in doing nothing, in my view. It's ended up in doing nothing. At the stand now, I think it's like to say that, yes, we have said something on disclosure at international level. The problem, I understand that there is a huge difference during the WIPO negotiations. We know different positions, so the only option they have is to go as minimal as possible. Because many countries were furious about it, we know that. Many countries will say, don't complicate the patent system. Don't complicate the patent system. By bringing this and that, you are complicating the patent system. I think you deal with it at the national level. Don't bring it here. We know that story. So I think it's like the only option to have a treaty. The option for me was, it's better not to have it in the treaty. I mean, with this treaty, I would prefer not to have it in the treaty. For me, I mean, it's radical, but that's always.
Is there any shown benefit of disclosure? Like, is there any example of, okay, yeah, and there had to be disclosure of country of origin or source, and that led to ability to implement benefit sharing? Or is it just purely theoretical?
You want to say?
No, I just want to make a counter-argument here. If I'm correct, under current patent law, there's no obligation for disclosure in addition to proving the invention. Yeah? You need to provide information while applying for a patent on the invention so that it is new. And that means all the technical details on the invention. But anything further in the sense of what we
is under current patent law, TRIPS and national patent law, not required to disclose. So there is an additional element in what the treaty now provides. Whether it's effective or not is something else. But just to be clear, it is bringing something new, additional to patent law that we do not have yet under international patent law. Some countries have it already, others not. Yeah, the idea is, of course, then to harmonize this additional standard worldwide. But that's whether it's effective or not depends on whether countries will ratify or not. That's a typical problem we have.
Do you
But
not,
again, there is an additional requirement that we do not know yet from current patent law.
okay, so I don't know patent law, but does that mean in the initial proving of the invention that you don't break it down into the novel parts and the not novel parts? Like, don't you have to prove which aspect of your invention is novel?
No, if I understand it correctly, Fikremarkos, the point is you have to, of course, prove the invention always, otherwise it's not patentable, but not in any detail the source of, or whether there's anything in the background, so to speak, where it might come from. You just have to prove that it's novel, that it's an invention.
I don't see the point what it adds to what there is already.
I mean, I guess it doesn't add the source. Of course, you don't know the source, but is it not implied with the things that you show? I mean, you have to prove the novelty or the innovative element of your invention, but does that not imply that the aspects that you don't identify as novel come from somewhere else?
To my understanding, not comprehensively, but
Okay.
correctly. That's the new point. Whether it's sufficient or not, I'm not judging on that.
Well, I think that's also questionable. That's what you said. I mean, we know that the patent, clearly there are requirements like the three.
And that's at least the traditional argument of the proponents of the treaty.
Yeah, that's a well-known argument, but if you start with one, so why do you require disclosure in the first place? Disclosure is also additional requirement. If you go to that line, so why do you require disclosure and not the other ones? They are already additional. This is not like the three, novelty, inventive state, industrial application of the invention. These are the requirements. But in addition, there is what we call disclosure requirement.
Now, under the treaty.
No, in the TRIPS agreement. Every patent law requires disclosure. Obviously, I think Article 29 of the TRIPS agreement talks about disclosure. Whether that disclosure covers it or not is another question.
Yeah.
But not the standard
disclosure on the technical issues.
Yes, so that's what we were debating. I think that's
exactly.
the whole point. And by the way, there are also additional formal requirements could be reasonable formal requirements could be added under the TRIPS agreement. You may say that these are reasonable formal requirements to strengthen the patent, the quality of the patent system. So there are other ways of, counter arguments to the typical argument saying, oh, we have only 1-3 requirement, you cannot add anything. I think these are, obviously people are talking about it, but I think it's possible to argue otherwise in my Yes.
So I wanted to pick up on your point. You just said that you would like there to be no treaty better than this one. And I think I agree because if I understood you correctly, states are not allowed under the new treaty to revoke a patent if you fail to disclose.
Yes.
But that's something that they could do before there was this treaty, right? So now the position of communities is weakened and the position of companies that abuse traditional knowledge is actually strengthened. Quite the opposite of what the treaty intended to do, right?
But you're right. I mean, if they wish to be party to if they ratify this treaty, I doubt it. We will see that, but I doubt it. If they have a national law which, says that if you don't disclose or the source, whatever, it will be revoked. Why should this country become a party to this treaty? What to do? What to get? What? I very much doubt. I think the national laws are way far in this regard. Even the regional laws are way far in this regard. The Andean community and so on and so forth. I don't see. That's why I say it's better to stay than having this kind of treaty. I don't see any value addition of this treaty. To me, I don't see any purpose. So I don't think those countries will become a member. They have to ratify it. So we'll see if they will ratify. If they will ratify, that means they have to change their law. They have to go back. Okay, we say it's.
Yeah, but I think that's not the political idea behind it.
The political idea behind it is that those countries who have the additional disclosure requirements and so on already in their national law, they will ratify, yeah, because it's their treaty, so to speak, in accordance already with the national law. They will ratify in order to have an argument based on reciprocity to put pressure on other countries to also ratify. Those countries who have not yet so advanced patent law. That's the political game. Yeah? You ratify not in order to change your law, but you ratify because you have your law already more advanced in accordance with the treaty in order to have a pressure argument towards other countries to get it in line with.
It will be in conflict with the treaty.
Why?
Because it says it should be revoked.
And I mean, the problem is
I mean, there are other details that, there are more stringent provisions there. I mean, this is like, it says nothing for me. So, more stringent national laws there. For example, 55 African countries are party to this treaty, that the FCFT. So it's clear, not only the disclosure of source, but also proof and so on and so forth. It's a conflict, obviously. So Africa is unlikely to be a party to this treaty. I don't see it. Why? I mean, because it's in conflict clearly with this treaty. That's why I say the future of this, we'll see, maybe, let's see, after 5 years, if we live long, we'll see 5-6 years how this will go far. But for me, I think the national laws have already advanced because the negotiation stayed for such a long time. Now, I think countries and regions have moved their own ways. We have more.
You mentioned that some states didn't want to have a more strict regulation or design of the treaty. Do you know maybe which states were hesitant to have more strict rules, maybe Western countries, or have there been stakeholders, companies that put in their positions and opinions in the treaty process? Do you have any information on that?
Yes, so there are different submissions by different countries in the TRIPS Council. Naturally, most of the Western countries do not want to have really cumbersome patent system. It's a known argument in this regard. They want to encourage patents. Patents are very important for their economies and so on. They have like huge companies that rely on patents and so on and so forth. So obviously, Western countries will say that let's deal this issue separately. In fact, it should not be here.
Also about China is also becoming much more important with that patent.
No, so far no. So far no. So far I didn't see that coming from China. It claims to be a developing country still, but so I don't see it coming from there. Even within Europe, for example, Norway, countries like Norway, they were really very flexible in this regard. Few countries in Europe, they were willing to consider that also. I think. Sorry, one. Okay.
Thank you. Was there any discussion about legal aid in the discussion about the treaty? Because, as you mentioned before, it is very unlikely that the indigenous people and traditional communities can fight any of these patents at all.
Yes. Well, so I'm sorry, I didn't get the question. They are likely to fight, yes.
Yes, but was there, because the claims are so expensive, is there anything regarding legal aid and like monetary assistance in the treaty?
I don't think there is a clear provision on that. Of course, states may cooperate and so on and so forth, but I don't think there is a clear provision on that. I think the one I mentioned to you, information system on genetic resource traditional knowledge, would have been a very good opportunity for a central international database. It would be easier even to check whether there is this traditional knowledge or genetic resources if we have a database, because we don't really know. That's the problem, really. problem now. We don't really know which traditional knowledge is where and who owns them and so on and so forth. We need that really at the international level. The WIPO Treaty talks about it, but it's mandatory. It's not mandatory. It's like permissive. If states wish to establish it, they can do it.
You talked about the Convention on Biodiversity. Are there any opportunities outside of the patent system to strengthen perhaps protections through the sources of biological diversity?
Well, of course, I mean, the IP system is just one tool, of course. This is another, I mean, the Convention on Biodiversity is a very broad treaty covering a wide range of issues. IP is just one component. But the other is sustainability, supporting small and indigenous peoples through different mechanisms. I think the majority of the provisions talk about conservation, preservation, and assisting local communities to continue and so on and so forth. So there are, that part is still there. But here, when it comes to intellectual property, I think that's a narrow component of it. It's just a few provisions in the Convention on Biological Diversity. But the rest is really other interventions to preserve genetic resources, to preserve traditional knowledge. It even talk about the possibility of registering allowing the participation of indigenous communities in decision making. So many things are included in the very comprehensive treaty on genetic resources. Christian, did you say anything?
Yeah, just the last word maybe on, I have a bit of a different interpretation
Of Article 5.3 of the revocability, because it says, the language says, no contracting party shall revoke, and so on and so forth, confer patent rights solely on the basis of applicant's failure to disclose information. So it's this solely which is important. You can, of course, ratify the treaty and revoke a patent any time on the non-novellability of the invention, of the non-invention that occurs. So
that's obvious.
yeah. So therefore, it's only, you cannot revoke solely on the point that an applicant did not disclose certain information. But you can revoke at any time under all the other criteria to revoke the patent. And that is to say, once you have the information based on disclosure, that it is not novel, because simply put, because it's based on traditional knowledge, of course you can revoke.
But the problem is, there is no disclosure. So can you revoke?
If it is done on a fraudulent basis, yes, you can.
So if you do not disclose just for the
Reason that as fraud, to, so to speak, disclose, to still keep it secret that the knowledge is coming from somewhere else, then of course you can revoke the patent.
Yes,
So I think
that's a fraudulent.
that's a pressure. And that is excluded from the prohibition.
Why do we attach this to fraudulent whatever? I mean, there is no disclosure. It means it's a mandatory provision. Revoke it, so that it will be an incentive for others also to clearly comply with it. To me, yes.
It's a compromise.
Yeah, compromise. Okay. Yes.
I think it's more than we have it currently. I wouldn't be that skeptical.
Okay.
So, I think it makes sense for Article 5.3 to only talk about disclosure, because that's what the treaty is talking
Yes,
about, right?
the rest.
But then still, Article 5.3 is working against the objective of the whole treaty. So, I mean, there might be a new obligation, but then there is, on the other hand, there is a limit to the policy power of states, and now they can't revoke policy. So, I mean, you're right, it's only about solely based on the case to disclose, but that's also all the treaty is talking about. And still, it's working against itself, the treaty. That
Yes,
doesn't have much sense.
that would be my position. I think solely, yes, of course, that's what we're talking about. It's about we're talking about disclosure, and we are saying that there should be consequence for that specific issue. But as you rightly said, there could be a different position. Yes,
Good.
Thank you very much.
Thank you very much.